All rise. Court of Appeal in the Fourth District to the State Court is now in session. The Honorable Vincent G. Portland Jr. All persons having business before the court draw near, give attention, and you will be heard. God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. We just have one case left on our docket this morning. COCCHIA, is that how you pronounce your client's name? Against the Augustines. And you may proceed when you're ready, sir. You got 20 minutes, and you want to say some rebuttal time?
Yes, Your Honor. I would like to save 5 minutes of my time for rebuttal.
5 minutes. I neglected to introduce the panel members. Judge Palmer is to my right, and Judge Lambert is to my left. You can fire away when you're ready, counsel.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. My name is Andrew Roy, and I represent the appellants Arthur and Josephine COCCHIA in this case. Your Honors, this case began when the COCCHIAs sold their gunsmithing business in Connecticut to Mr. Augustine in 2009 for over $600,000. This was a seller finance deal, and that was to be the COCCHIA's retirement. Mr. Augustine made only one or two payments on...
How did you get Mrs. Augustine as a co-obligor on the judgment, or how did your client do that? Was it just because she defaulted? Is that what happened?
Your Honor, Mrs. Augustine became an obligor on the judgment via the domestication of the judgment in New York and then the subsequent entry of the fraudulent transfer judgment out of New York. So Mrs. Augustine was a defendant.
I mean, what was the source of her liability? How was she liable on the... wasn't the judgment originally against Robert?
That's correct, Your Honor. It was only against Mr. Augustine. That was the judgment rendered out of Connecticut. Miss Augustine became obligated.
And what was the legal basis for getting her?
Well, Your Honor, the focus of the New York judgment is less about Miss Augustine's personal obligation and more about the entry of a final judgment of concerning the fraudulent transfer, where she was the recipient of a fraudulent transfer. And so that's how she became obligated.
Is she obligated on the underlying judgment if you were to inherit money or win the lottery next week? Is she obligated for the $500,000 or $600,000?
Your Honor, the extent of Mrs. Augustine's liability personally is only the attorney's fees that were entered in the New York judgment.
Mm-hmm. It doesn't seem to be the position, though, that the brief suggests or that the judgment in New York suggests. It says, in addition to the money that was determined owed by the Connecticut court.
That is correct, Your Honor. There is part of the position that we take is that the plain language of the judgment.
It certainly wouldn't be fraudulent, would it?
In terms of the assessment of the judgment against Mrs. Augustine?
Yeah.
Well, the crux.
I was just tongue-in-cheek there because it's a fraudulent transfer.
Yes, Your Honor. The crux of the fraudulent transfer judgment, which is what
happened? Okay, so the court in New York set aside the fraudulent transfer. What is the legal effect of that?
That is the crux of this entire case, Your Honor.
Answer my question.
Yes, Your Honor.
What's the legal effect of it?
The fraudulent transfer, when we talk about fraudulent transfers, the understood the general purpose of a fraudulent transfer.
Okay, I'll answer it for you because it's taking you too long. The effect of setting aside the fraudulent transfer is it goes back to the way it was before, right?
No, Your Honor, it's more than that.
More than that.
The purpose of a fraudulent transfer is to recover something that the creditor could have collected from to begin with, and so
Never could have.
No, that's not correct, Your Honor. Under this record,
I mean, there was a 2008. I mean, the case actually started in the broadest picture in 2008 when the Augustines acquired this property as husband and wife. That's the property that eventually got fraudulently transferred according to the New York court. So the Connecticut judgment, the money judgment, the deficiency judgment against Mr. Augustine in 2011, that never could have been levied. The property in Clearmont could never have been levied upon without any transfer, in your view, right?
Well, no, Your Honor, that's not correct.
Wait a minute.
On this.
No, that's not what I'm asking you. If I have a judgment against one spouse, and forget about all the stuff that goes on in New York, that judgment cannot be satisfied by levying on entirety's property. You have to agree with that, right?
Under Florida law, yes, Your Honor, but on this record, that does not apply here.
Well, that's certainly your view.
Because of what? Because why?
Because we have the fraudulent transfer judgment out of New York that determined this property to be collectible. The tendency by the entireties is, first of all, it's the first time it ever was raised was on appeal. And second of all, to the extent that it ever could have been raised, it could have been raised and should have been raised in the New York.
And you would have lost.
That's correct. I think
Okay,
that's
what we're
probably
trying-
correct,
that's-
Your Honor.
Yeah, right. So you have a transfer an unnecessary transfer in 2010 that has now morphed itself into a fraudulent transfer, so now to the extent that you now want to be able to levy upon what is clearly homestead property, because you don't challenge the finding of homestead property.
Well,
Isn't that it?
well, it's homestead as it relates to,
It's homestead, period.
but
I
that is.
understand your argument. I mean, you don't, it's okay to actually concede the obvious when you're at oral argument.
Well, it is, yes, Your Honor.
It is
and I'm-
homestead property.
It is homestead property now.
You're
As it-
asking to be levied upon.
As it relates to my clients, it is not protected homestead because of the fraudulent transfer judgment issued out of New York. That judgment ultimately determined that this property is collectible.
What did the New York court, where did the New York court ever say it was collectible against this piece of property?
When we look at the language of the judgment, one of the recitals states that the purpose of the fraudulent transfer action is to execute upon the judgment. So the recital, and this is in the judgment, states that whereas the plaintiffs having commenced this action against the defendants to set aside fraudulent conveyances in order to execute upon a judgment. And then it goes on to say that that judgment or the transfer is set aside. And when we talk about what is the purpose of a fraudulent transfer judgment, a fraudulent transfer judgment assumes it requires that something of value was transferred away from the creditor. And so on this record, Your Honors, there was something of value that the COCCHIAs could have collected from, and that was Mr. Augustine's interest. And because he transferred it away, and
Did the New York court find that he could execute upon that explicitly?
no, Your Honor, there is not express
You didn't ask
language.
the New York court to find that this was not covered by Florida homestead law, right?
No, that's, it was an affirmative defense that should have been raised by the Augustines in that collection action. So we have.
What was the remedy requested in New York was what? Set aside the transfer, correct?
It was to establish that this transfer was fraudulent as to the COCCHIAs,
Okay.
as judgment creditors against Mr. Augustine,
Okay,
which
and did you ask for a declaratory judgment that it was not homestead or that it was in fact then executable upon once the transfer was set aside?
Well, what it did determine is that it has evidentiary value under the full faith and credit clause that is enforceable
Full
here.
faith and credit isn't an evidentiary issue. It either has some binding effect because of full faith and credit, or it doesn't. It's not evidentiary to look at along with other things, correct?
Well, it is evidentiary in the sense that if res judicata applies, it binds the parties as to that particular issue. And that is what we have before the court is there was a determination
The New York court had no authority to levy on Florida property.
to levy on Florida property. That's correct, Your Honor, but it did
Had
have,
to get a Florida judgment.
no, Your Honor, that there
Had
was,
to domesticate the New York judgment in order to levy on the Florida property.
that is correct. But the New York court did have jurisdiction to determine the existence of a fraudulent transfer judgment, or
That's only part of the story, though. They didn't address the issue of whether it's homestead, right?
Well, they necessarily did, because that would have been.
Necessarily did. Was it raised in the pleading? Did you ask the New York court to declare that it was not homestead?
No, Your Honor, but it didn't need to be raised as a prima facie
I don't
case.
understand why you keep saying that it needed to be raised in a proceeding before a court that had no authority to levy on the property.
Well, Your
Why couldn't it be raised just like it was raised in connection with the attempt to levy on the property in Florida?
Because the parties are bound by the New York judgment, which finds that this was a fraudulent transfer. So what Mr. Augustine had was something of value that the COCCHIAs could have collected against. That comes with the New York judgment to Florida.
Did
And
you
that
have
is,
a question, Judge Palmer? He's answered mine.
No, go ahead.
and Your Honor's coming back to the fact
Well, just
that,
let me ask you this as a hypothetical proposition, okay? If a creditor gets a judgment in a state other than Florida against the defendant, and the judgment says, you are hereby authorized to levy execution on any property held by the defendants. Okay, and then they domesticate that foreign judgment in Florida. Does the fact that the New York court, or the out-of-state court rather, authorizes levy on any property, is that binding on a Florida court when a homestead issue is raised, when an exemption is raised?
No, Your Honor, and that's because the focus here, the focus in Your Honor's hypothetical is just the entry of the underlying money judgment, and that did not adjudicate anything as it relates to the collectability of property as between the parties. I concede that New York did not have in rem jurisdiction over this.
A fraudulent transfer, if you assume it is a fraudulent transfer, and the issue of whether or not property is homestead, one is an apple and one is an orange. Isn't that true?
No, Your Honor,
It could
because
still be homestead. That you have the husband and wife deeding the property to the wife. Could still be the wife's homestead, or it could still be the husband and wife's homestead, assuming that you set aside the transfer.
as it relates to the transfer itself, but for the transfer, the Connecticut judgment could have attached to Mr. Augustine's interest here in Florida before it ever became their homestead. We don't disagree with
No,
it.
we can't.
It was entirely.
It's entirety's property. You can't, it's inseverable. I mean, you can't say, okay, this is non-homestead tenancy by the entirety property. I have a judgment against one of the spouses. I can levy upon the tenancy by the entirety property, but I only want the husband's part of that. You can't do that. That's what I think we're having a disconnect about.
It's possible if the tenancy by the entirety exemptions is waived. And the first time it was ever raised was on appeal. Even in the bankruptcy case that the Augustines filed, they didn't even claim it as tenancy by the entirety. They didn't claim that real property there. And so, yes, Your Honor, in Florida, under Florida law, if something is held tenancy by the entirety, I don't dispute that if there is only a creditor against one.
But for what your clients perceive to be a fortuitous, unnecessary transfer of property in 2010, we wouldn't even be having a discussion today because the property would have been tenants by the entirety property since 2008, and the fact that your clients got a judgment against the husband individually, those two are two ships that pass in the night and don't connect. Isn't that absolutely correct?
Your Honor, no.
That's not absolutely correct?
If they pursue the fraudulent transfer,
You're messing with, no, there is no 2010 transfer, so it shouldn't be your response to what I'm saying right now that, yeah, there was a 2010. There is no 2010 transfer in my hypothetical. There's a property that was bought by the Augustines in 2008 before they ever had a gunsmithing business that was financed by your client. Things went south in the gunsmithing business. Your clients properly get a deficiency judgment against Mr. Augustine alone. Your clients then say, okay, we need to try to collect against it. I see that these two people, the husband and wife, own property in Clearmont. Whether it's homestead or vacation property, it's not homestead, it's tenancy by the entirety. You could not have taken that Connecticut judgment and levied upon that property. Isn't that accurate?
it has to be raised as a defense, as an exemption.
Your answer is that's not.
If they raise it as tenancy by the entirety.
Back into play this 2010 I'm saying that never happened. There is nothing. Forget it. Put it out of your mind.
Yes, Your Honor.
Then I'm right.
Well, if
I have to be right.
It still has to be raised, Your Honor. It's if we bring, under Your Honor's hypothetical, if we bring the Connecticut judgment here and we domesticate it, there's no objection to the placement of the lien against the property, and there's no otherwise prior to the levy on the property.
They domesticate. They just made it a judgment here in Florida, so that at some point in the future, if Mr. Augustine has property in his own name, and your judgment's perfected, then they could levy upon his individually owned property.
But the tenancy by the entirety.
They don't have to say, okay, they have no defense to the domestication of the Connecticut judgment, assuming it was validly entered in that court had jurisdiction. So they say, okay, we got a judgment in Connecticut. They're not in Connecticut anymore. They're in Florida, so we're going to domesticate it in Florida. What's the defense?
Well, if they domesticate it in Florida, in the defense that the Augustines can raise, they can't defend against the.
To that.
you seem to be saying that they needed to then raise the homestead defense to the domestication, which makes little sense to me.
Well, if, say it went all the way through to levy,
Well, which, yeah, at that point, if they say we're moving, we want the sheriff to levy upon our tenancy by the entirety property, then they would do, I assume, what they did here. They'd say, well, wait a minute, you can't levy upon that.
Right,
And
but-
they would win, and if they came up on appeal, the appellants, the COCCHIAs would lose.
absolutely. But if they don't raise it and the home gets sold, if they don't raise it and the home gets sold, you can waive a tenancy by the
I
entirety
think
exemption.
central to your entire argument, Counselor, is this notion that in connection with the New York proceeding, that they had a duty to raise defenses that pertain specifically to the right of the creditor to levy on this particular property.
That's correct, Your Honor.
What is your authority for that?
It is based off of New York law and also,
No, I'm asking you for your authority. Give me the case that says that here's the abstract legal proposition that you espouse, that when a creditor proceeds on a foreign judgment in a foreign jurisdiction, that it is incumbent at that time on the debtor to raise exemptions that might apply should that creditor subsequently endeavor to domesticate that judgment in Florida.
the authority, Your Honor, is the Hoyt case out of New York.
The Hoyt case.
Yes.
Okay,
and
what
we
were the
do
facts
cite-
of that case?
In that case, this is an 1882 case out of New York. In that case, the court examined whether something of value was transferred by the debtor to somebody else out of the ability of the creditor to collect. And in that case, it concerned the waiver of an account receivable that may have been bad because the person who owed the money to the debtor was insolvent. And so there's a question as to whether what was transferred, or this forgiveness of this debt, was something of value that the creditor could have attached to satisfy its judgment. And because there is that requirement that a fraudulent transfer required there initially, this is the prima facie case, initially to be something of value to be transferred, that means that it was also collectible at that time. And so, and when we look also at New York law on it as it relates to default.
I don't even know how New York law could have anything to do with the procedural point at which in a Florida proceeding to domesticate a New York judgment, when procedurally must a debtor raise the homestead exemption?
In this particular piece here, when we talk about a fraudulent transfer, which is in the nature of a tort, it's a damage.
Now, don't forget, we're talking about two things, okay? There are two distinct concepts, because property can be held as tenants by the entireties and not be homestead, or it might be homestead. Okay, so by the time and when this New York proceeding was going on, as I understand it, this property was not yet homestead, because these people had not moved here permanently, is that right?
At the time that the Connecticut judgment was entered, it was not their homestead.
Connecticut.
And even after,
Okay, how about
immediately
the New York
before,
judgment?
before the New York judgment was entered, it became their homestead in April 2012. And so they could have raised it as a defense in
But
the,
why do they have to raise it in a New York proceeding when you haven't attempted to levy on the property yet?
because the New York proceeding states that something of value was transferred away from the COCCHIA's ability to collect. That is a final adjudication as to that right. And it is a tort that
Well,
binds.
the final adjudication was to set aside the transfer, right? The only remedy that was asked was set aside the transfer, correct?
That's correct, Your Honor.
Okay, it is not a defense to, this is a fraudulent transfer, that this is homestead property, right? That wouldn't be a defense to that. That would only be a defense if they sought a declaration that it wasn't homestead.
Well, no, Your Honor. Both tenancy by the entirety and homestead would have been an absolute defense to the fraudulent transfer action, because it means that what the COCCHIAs were seeking to collect against was not collectible.
Couldn't you fraudulently transfer a piece of homestead property?
No.
You could never fraudulently transfer a piece of homestead
I
property.
believe that's correct, Your Honor.
So if I held a mortgage on your property, and it's homestead property, and you tried to transfer it away to somebody else, I, as the mortgage company, couldn't argue that that was a fraudulent transfer?
Well, it's a little bit different for a mortgage company because it's a voluntary lien, and that's an
My question
exception.
was, could you ever fraudulently transfer a piece of homestead property?
As it relates to an involuntary creditor, no, under Florida law.
You're nearing exhausting your time, counsel.
Your Honors, may I reserve the rest of my time for rebuttal?
Okay, now, but I'm not going to let you argue anymore if he doesn't argue. That's rebuttal time you got left, you understand?
Yes, Your Honor.
Okay. Did you feel constrained to argue? Anybody got any questions for Mr. Jordan?
Nope.
Okay, we're in recess, thank you.
Thank you, Your Honor.